So students, today we will discuss about alternative dispute resolution like arbitration, conciliation, mediation, Lok Adalat, etc. And we will discuss with its meaning and scope and its connection with the section 89 of the CPC. So what is alternative dispute resolution? We can say that it's an alternative for the conventional method of solving disputes. What is the conventional method? Yes, approaching a court before approaching a court of law for settling the dispute. And we can say that in early times also there were some kinds of ADR were prevailed in the society, like Kula. They resolved the dispute related with family, community, caste, and tribe. And there were Shreni to resolve the disputes of businessmen and artisans. And there were Puga to deal or to resolve the disputes of traders. And of course, Panchayat. We heard about this term, Panchayat, for considering the dispute of people of that Panchayat. So, in early times, this this ADR was a voluntary action from the people or the parties to the dispute, but later on, this ADR got a statutory recognition. For example, we can say that Arbitration and Conciliation Act 1996 and Legal Service Authority 1987. Moreover, Section 89 of CPC incorporated ADR also, and the legislature had acted so because with an intention to promote ADR in India. So what is Section 89 of the CPC? Section 89 of the CPC talks about the settlement of dispute outside the court. I'll explain it. Suppose a case is going on before the court, and at any stage or at a stage the court feels that yes, there are some terms of settlement. The court will inform about the settlement terms of settlement to the parties and wait for their consideration. If the parties agree that yes, they will go for terms of settlements, the court may refer the matter to arbitration, conciliation, or settlement through Lok Adalat or mediation. The intention behind the court is to dispose the case without any delay. Now we will see why the courts itself promoting these ADR techniques. Because we know that there is no adequate number of courts and judges available in our country. And the number of cases are increasing day by day because the population in our country is high. And the cost of litigation is considerably increasing. Even the court fees, lawyers' fees, and related expenses all will be burden upon the litigants. And of course, there will be delay in disposing the cases because of our complicated laws and technicalities to be followed while going for the conventional method of solving the dispute. So we will check it out what are the benefits of ADR. Normally, this ADR is less time consuming one because the parties can settle their dispute matter within a short time itself. It is less costly when compared with the normal judicial proceedings before the court, and no much technicality involved in ADR like the same with court. Even the matter can be resolved in an informal way in ADR. And the parties can go for ADR even if the case is pending before the court of law. The parties are free to choose their time, place, and procedure for resolving their dispute. Suppose the disputed matter involves any technical thing, the party can go for a person who is expertise in legally as well as in technically as an arbitrator and resolve the dispute with no time. For example, if the dispute is related with construction, the parties may agree to choose one person who is an engineer as an arbitrator and they get their dispute solved within no time. So all these features are helping the ADR to increase or to gather people's belief, and the people are very well satisfied with the outcomes from the ADR. So we can, without any doubt, we can say that ADR is a successful alternative to the conventional method of adjudication.